Welcome to Ask the Lawyer, International Edition, the radio show that brings you the latest trends in immigrating to the United States. Hosted by attorney Brian Figueroa of the law firm Figueroa and Associates. This program is designed to provide valuable insights for those who wish to live, work, study, or invest in the U.S. Whether you're an international student seeking educational opportunities, an entertainer looking to break into the U.S. market, or a business owner wanting to expand your operations and tap into the vast U.S. economy, this show is for you. If you're an investor exploring options in the U.S. or someone with family or friends already living here, you won't want to miss the important information shared on Ask the Lawyer, International Edition. Each week, we dive into critical topics that help you navigate the complexities of U.S. immigration and business law. Special guests include experts in business development, elected officials supportive of immigration, business owners, and nonprofit leaders who provide real-world advice and guidance for those wanting to build a future in the U.S. The law firm of Figueroa and Associates was founded not only to serve our clients, but to contribute to the greater good. We understand the importance of helping individuals and businesses achieve their American dreams, and we are committed to providing the legal expertise and support needed to make that happen. So whether you're an entrepreneur looking to open a branch of your business in the U.S., an investor ready to explore opportunities, or someone hoping to migrate and build a new life in America, you should tune in and learn from this informative program. Ask the Lawyer. International Edition is your resource for understanding U.S. immigration trends, business opportunities, and legal strategies. Call now. For personalized legal advice, contact the experienced attorneys at Figueroa and Associates today. Our team is here to help you navigate the path to success in the U.S. Thank you for listening to Ask the Lawyer, International Edition with attorney Brian Figueroa. Visit us online at askthelawyer.us or call today to schedule your consultation.
Looking for a lawyer who brings confidence, charisma, and nearly 30 years of legal muscle to your side? Meet Brian Figueroa, Esquire, New York's #1 immigration attorney and a trusted name across the city and beyond. He's not just experienced, he's exceptional. Known for his sharp legal mind and undeniable presence, Mr. Figueroa handles it all. Immigration, estate planning, family law, business matters, you name it. Whether you are starting a business, protecting your legacy, or reuniting your family, he's the lawyer who listens, who cares, and who gets results. Today, we confront a disturbing trend and a legal minefield affecting immigrants and travelers alike. First up, strip searches at JFK Airport, a shocking rise in invasive procedures targeting elderly travelers, visa holders, and even green card holders. Are your rights being violated at the airport? Next, the latest legal developments on birthright citizenship. We examine what the recent developments mean for children born on U.S. soil to immigrant parents. And finally, the high stakes of false U.S. citizenship claims and fraudulent immigration documents, why even a single misstatement can lead to deportation, permanent bars, or even federal criminal charges. From strip searches to birth certificates, this episode is your roadmap to understanding your rights, your risk, and your legal remedies. Remember, this is Ask the Lawyer. The number to call, the number to share, and the number to keep is 855-768-8845. That's 855-768-8845, or you can schedule an appointment at www.askthelawyer.us. That's www.askthelawyer.us. Ask the Lawyer starts now.
Planning to travel to New York for the summer? In this segment, strip searches at JFK International Airport, one of the busiest ports of entry in the United States. The problem unfolds. Over the past year, numerous travelers, many elderly, chronically ill, or non-citizens, have reported being pulled aside at JFK, escorted into private rooms, and ordered to remove their clothing, sometimes even their underwear. These are not your routine pat-downs or TSA scans. We're talking invasive strip searches, often conducted by Customs and Border Protection or Transportation Security Administration agents. In particular, green card holders, visa travelers, and individuals with medical devices have borne the brunt of these increasingly aggressive searches. Legal experts say that since early 2025, federal enforcement at the border has intensified, especially under the banner of immigration control. What the law actually says. Let's break this down legally. Under the Fourth Amendment, Americans are protected from unreasonable searches and seizures. But, and here's the key, at international borders, that protection is more limited. U.S. courts distinguish between what's considered a routine search, like a bag check or a body scanner, and a non-routine search, like a strip search or body cavity exam. To strip search someone at the border, authorities must have something called reasonable suspicion. That means they must articulate specific facts suggesting a traveler is hiding drugs, weapons, or other contraband. And what doesn't count? Your age, medical condition, race, religion, or nervousness alone do not justify a strip search under the law. Segment 3. What is reasonable suspicion? Here's what courts have said might count as reasonable suspicion. A drug-sniffing dog alerting to your person. Suspicious travel patterns or evasive behavior. False documents or contradictory answers. But here's what doesn't justify a strip search. Wearing a colostomy bag. Using a walker or wheelchair. Speaking a foreign language or wearing a headscarf. Any such search without actual suspicion is a violation of constitutional rights. Plain and simple. What are your rights? Let's talk rights, because knowledge is power. If you're a U.S. citizen, you cannot be denied re-entry into the country, even if you refuse a strip search. Authorities can delay you or inspect your devices, but they can't bar you from coming home. And since a 2024 court ruling, CBP must get a warrant to search your smartphone at JFK. Green card holders also have strong protections. Refusing a strip search may cause delays, but it won't result in instant deportation. Immigration courts, not agents, decide who stays and who goes. But if you're traveling on a visa, things are trickier. CBP can deny you entry for refusing a strip search, revoke your visa, or put you on the next flight out. Refuse with respect, but know your tools. If you're asked to submit to a strip search, here's what you should do. Say, I do not consent to a strip search. I want to speak with a lawyer. Ask, what is the basis for this search? Get badge numbers. Write down everything. Never sign any waiver or confession without legal counsel. Remember, just because you're in an airport doesn't mean your rights are suspended. Segment 6. Legal recourse and real cases. Ageist. You're probably wondering, has anyone ever fought back? Yes, and with results. In 2010, a $33 million settlement was awarded in NYC over illegal strip searches at Rikers Island. In 1997, black women at O'Hare Airport won $1.9 million in a racial profiling case. At JFK itself, elderly women with medical devices were searched in 2011. While those cases didn't lead to payouts, they sparked outrage and national headlines. If you're a victim, you can file lawsuits for unreasonable search under the Fourth Amendment, due process violations under the Fifth, discrimination under equal protection, and even international tort claims if you're a foreign national. Reform and the road ahead. The ACLU and immigrant rights groups are working to reform these practices. The 2024 court ruling requiring warrants for phone searches at JFK was a major win. But broader reform is needed, especially to stop profiling of the elderly, immigrants, and people with disabilities. There are growing calls for officer retraining, clearer search protocols, stronger oversight on border searches inside the U.S., including the so-called CBP 100-mile zone. Remember, here's the takeaway. Just because you land at JFK doesn't mean you check your rights at the gate. Strip searches must meet strict legal criteria, and if they don't, you have the right to push back. If you or someone you know has experienced an invasive search, assert your rights. Document everything. Refuse to sign anything unclear. Get legal help. Lawsuits matter. Awareness matters more. Ask the lawyer. If you or a family member had this experience, ask the lawyer. Call 855-768-8845 or schedule an appointment at askthelawyer.us.
Do you have a legal issue, question, or concern? Turn to Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us. You can also register for our paralegal program, get legal news, business consults, or other information on educational issues. Yes, ask the lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us.
Hello, people out there. I'm Julian from St. Lucia, and I'm here in Mr. Figaro's office. Mr. Figaro represented me for past, 10 years. I was going through some removal proceeding, and I go to several lawyers. Some of them asked me to run away. Some of them said they cannot do anything for me. And my Consulate General, Jeremiah Hyacinth, he recommended me to Mr. Figaro. And right now, I go through a lot with Mr. Figaro. Mr. Figaro is the only one that stands with me. And right now, I believe I'm the happiest man in this world right now with a 10-year green card. 10-year. And in the next 2.5 years, I'll be filing for my citizenship. And that's me, happiest man today. Thank you.
Hello, my name is Mary Campbell, legal assistant at the law firm of Figaro and Associates, and your presenter with this week's immigration news. Supreme Court weakens nationwide injunctions. Birthright Citizenship debate roils legal landscape. In a landmark ruling that narrows the power of the federal judiciary and leaves unresolved a critical constitutional issue, the U.S. Supreme Court ruled Friday, June 27, that lower courts may no longer issue nationwide injunctions, decisions that had often blocked federal policies from taking effect nationwide. The case, Trump v. CASA, also centered around the Trump administration's controversial Executive Order 14,160, which seeks to end birthright citizenship for children born in the U.S. to undocumented or non-citizen parents. Judicial restraint on nationwide injunctions. By a 6-3 vote, the court's conservative majority held that district courts may only issue injunctive relief binding on the parties before them, not the entire nation. The ruling represents a dramatic rollback of a legal tool long used to pause sweeping federal policies while courts evaluated their constitutionality. In writing for the majority, Chief Justice John Roberts emphasized that the role of the judiciary is to resolve concrete disputes, not to dictate national policy from a single courtroom. Critics say the decision could lead to legal fragmentation, where policies apply differently nationwide, and vulnerable populations lose a vital shield against unconstitutional executive actions. Also writing for the majority, Justice Amy Coney Barrett criticized such sweeping judicial orders, stating, "When a court concludes that the executive branch has acted unlawfully, the answer is not for the court to exceed its power to." Birthright citizenship left unsettled. Despite addressing Executive Order 14,160, which reinterprets the 14th Amendment's citizenship clause, the court avoided directly ruling on whether children born on U.S. soil to undocumented parents are guaranteed citizenship. The justices instead held that the question must continue to be litigated in lower courts across multiple jurisdictions. That ambiguity has sown confusion nationwide. Federal judges in at least 4 districts had blocked enforcement of EO 14,160 earlier this year, citing constitutional concerns. However, with the court's ruling, those blocks now only apply to plaintiffs in the respective cases, not the broader public, leaving other children at risk of being denied citizenship. Reactions across the political spectrum. President Donald Trump celebrated the decision during a White House press briefing just minutes after it was issued. "This was a big decision," he said. "An amazing decision, one that we're very happy about." He reaffirmed his administration's commitment to ending the abuse of the Citizenship Clause, which he and advisor Stephen Miller have long targeted as central to reshaping American immigration law. However, immigration advocates and civil rights organizations condemn the ruling as a dangerous step toward authoritarianism and racial exclusion. Like most Americans, I've always believed the U.S. was a place where our constitutional rights were guaranteed, where citizenship, especially constitutionally enshrined birthright citizenship, was sacred and protected, said Vanessa Cardenas, executive director of America's Voice. Today's Supreme Court decision not only weakens the judicial branch and its essential role as a check and balance against executive overreach, but also threatens to unravel the very promise that a child born in America is American. If the Trump administration succeeds, millions of children born on U.S. soil will be stateless. Cardenas characterized the ruling as part of a broader strategy to redefine who counts as American. Make no mistake, this is part of the Trump-Miller agenda. It's a dangerous erosion of our rights and a dangerous expansion of Trump's imperial power, with serious implications far beyond immigration and birthright citizenship, she warned. Legal and political implications. While the ruling technically leaves birthright citizenship intact, for now, it effectively greenlights Executive Order 14,160 to be enforced piecemeal wherever injunctions have not been secured. Legal experts predict this will trigger a flood of new litigation, creating uneven citizenship rights across state lines. The ruling could result in American-born children of undocumented parents having different legal statuses depending on where they're born. That's unprecedented and likely unconstitutional. Legislators on Capitol Hill are already responding. Some hailed the ruling as long overdue judicial humility, while other leaders have called for legislation to explicitly protect birthright citizenship and restore the scope of judicial injunctions. Looking ahead, the Supreme Court's ruling in Trump v. CASA sets the stage for a new era of legal battles over who is entitled to the rights and privileges of American citizenship. Immigration is once again at the center of national debate, and the issue of birthright citizenship is poised to become a defining fault line in 2025 and beyond.
This show is a production of IQ Inc. Marketing. If you would like to advertise your product or service on this show to the U.S. and Caribbean markets and through our multicultural publications in New York, please call 866-435-3286 or send an email to info@myiqinc.com.
Are you an artist, band, or musician looking to perform in the United States but need help navigating the complex visa process? The law firm of Figaro and Associates, located in Brooklyn, New York, is here to assist. Our experienced immigration attorneys specialize in entertainer visas, including P1, P2, and P3 visas. We'll guide you through every step, from securing a U.S. sponsor to filing the necessary petitions and preparing for your consular interview. With our legal expertise, we'll ensure that your visa application process is smooth and stress-free so you can focus on what you do best, performing. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845. Figaro and Associates, your trusted partner in U.S. immigration law for entertainers.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.
False U.S. citizenship claims and fraudulent documents by immigrants, legal consequences and defenses to deportation. In the complex landscape of U.S. immigration law, one of the gravest mistakes a non-citizen can make is to falsely claim U.S. citizenship or to present fraudulent documents indicating U.S. citizenship. Such misrepresentations, often made under duress, desperation for employment, or misinformation, carry severe immigration consequences, including mandatory removal and permanent inadmissibility. This article provides an in-depth legal analysis of the consequences under the Immigration and Nationality Act, INA, examines related criminal liabilities, and outlines available defenses and waivers where applicable. 1. Forms of false U.S. citizenship representation. Immigrants may falsely claim U.S. citizenship in several common ways. 1. Falsely completing the I-9 form. Under federal law, all employers must verify the identity and employment authorization of new hires using Form I-9. One of the boxes on this form allows the employee to attest to being a U.S. citizen. If a non-citizen, particularly someone without legal status, checks this box falsely, it can trigger severe immigration penalties under INA 212(6) CE. 2. Use of fraudulent documents indicating citizenship. This includes presenting fake or unlawfully obtained U.S. birth certificates, Social Security cards, U.S. passports, or other identification documents implying U.S. citizenship. 3. Oral or written false claims to government officials. This includes telling a law enforcement officer, immigration officer, or other government personnel that the individual is a U.S. citizen, either verbally or on official documents such as voter registration forms, loan applications, or immigration benefit forms. 2. Legal consequences of false claims to U.S. citizenship. Under INA 212(6) CE and INA 237(3) a non-citizen who falsely represents or has falsely represented himself or herself to be a citizen of the United States for any purpose or benefit under federal or state law is inadmissible, barred from entering or adjusting status in the U.S., and deportable, subject to removal proceedings. These consequences are severe and typically permanent. A. No waiver available for most false claims. Unlike other forms of fraud or misrepresentation, under INA SS 212(6) CE, false claims to U.S. citizenship do not generally qualify for a waiver. There are very few exceptions. B. Criminal penalties. Falsely claiming citizenship can also result in federal criminal prosecution for falsely claiming citizenship, punishable by a fine or imprisonment up to 3 years. Document fraud, use of fraudulent documents, false statements to federal officials. A criminal conviction can add to the individual's grounds for deportability or bar other forms of relief. 3. Limited exceptions to inadmissibility or deportability. While the law on false claims to citizenship is strict, there are narrow exceptions and possible defenses, including A. The reasonable belief exception. An individual is not inadmissible if the false claim was made before September 30, 1996, or at the time of the claim, the individual reasonably believed that they were a U.S. citizen. Key factors courts consider: whether the person was a minor at the time, whether their parents or guardians were U.S. citizens or had falsely claimed the person was a citizen, the individual's understanding of their immigration status, the totality of the circumstances, education, sophistication, and intent. This exception is narrowly construed and difficult to prove. B. Automatic citizenship misunderstanding. In rare situations, a person may genuinely, but mistakenly, believe they derived U.S. citizenship from a parent through derivative or acquired citizenship. If this belief is reasonable and based on the facts, the parent naturalized while the child was a minor living in the U.S. with lawful status, the defense may be valid. See lack of intent or knowledge. Some individuals may check the U.S. citizen box on an I-9 form due to language barriers, literacy issues, or employer coercion. Where there is no intent to defraud, the government may have difficulty meeting its burden of proof for removal. 4. Relief from removal. Possible defenses in immigration court. If an immigrant is placed in removal proceedings for false claims to U.S. citizenship, the following forms of relief may be considered. A. Cancellation of removal for non-permanent residents. Requires 10 years of physical presence, good moral character, and exceptional hardship to a qualifying U.S. citizen or LPR relative. Unfortunately, a false claim to citizenship generally disqualifies applicants due to the good moral character and admissibility requirements. B. Adjustment of status with 212(6) CE relief. Very limited. If the false claim was made before September 30, 1996, or the individual qualifies for one of the statutory exceptions, adjustment may be possible. No standard I-601 waiver exists for false claims. C. Prosecutorial discretion or deferred action. In cases involving sympathetic facts, such as long-term residents, U.S. citizen children, or victims of trafficking or abuse, DHS may exercise prosecutorial discretion not to pursue removal. This is a policy-based remedy, not a legal right, and its availability fluctuates with presidential administrations. DVAWA, T-visa, or U-visa protections. If the false claim was made under coercion, as part of human trafficking, or while suffering abuse from a qualifying U.S. citizen or LPR spouse or parent, victims may qualify for VAWA, T, or U visas, all of which include certain waivers for immigration violations. 5. Policy considerations and reform. The strict consequences for false claims to U.S. citizenship have been widely criticized as disproportionate and inflexible, especially when compared to waivable fraud or misrepresentation. Many immigrants who make such claims are young, misinformed, or coerced, and the permanent bar creates a harsh result for minor mistakes. Immigration advocacy groups have long pushed for expanded waivers for good faith mistakes, proportionality based on the severity of the offense, deference to equities like long-term residence, family unity, and humanitarian concerns. So far, however, Congress has not amended this portion of the INA. 6. Conclusion: falsely claiming U.S. citizenship or using fraudulent documents to do so is one of the most serious violations under immigration law. Such actions typically result in lifetime bars to relief, unless an individual qualifies for one of the rare exceptions. Immigrants who find themselves accused of making such false claims, whether on the I-9 form or elsewhere, should immediately consult competent legal counsel like the law firm of Figaro and Associates to assess whether they may raise defenses under the law, argue a lack of intent, or qualify for humanitarian relief or prosecutorial discretion. While the road is difficult, each case turns on its specific facts. An early intervention by a skilled attorney may offer a viable path forward.
Do you have a legal issue, question, or concern? Turn to Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us. You can also register for our paralegal program, get legal news, business consults, or other information on educational issues. Yes, Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us.
This show is a production of IQ Inc. Marketing. If you would like to advertise your product or service on this show to the U.S. and Caribbean markets and through our multicultural publications in New York, please call 866-435-3286 or send an email to info@myiqinc.com.
Thank you for listening to Ask the Lawyer International Edition with attorney Brian Figaro of the law firm Figaro & Associates in New York. We hope you enjoyed the show, which featured immigration visitors visa, starting and doing business in New York, entertainment and business visas, religious visas, and much more. Whether you are outside the U.S. or have family in New York, the number to call, share, and keep is 855-768-8845. That's 855-768-8845. Please schedule a consultation with us at www.askthelawyer.us. That's www.askthelawyer.us. This is Ask the Lawyer, International Edition. You have questions? We've got the answers.